If you became a US citizen through naturalization, there's a question that may have crossed your mind this year, and it's not a small one. Can that citizenship ever be taken away? In 2026, immigration enforcement feels louder, faster, and more aggressive than it has in a long time. Old files are being revisited, background checks are being run against new databases. Paper applications that once sat in storage boxes can now be pulled up on a screen in seconds. Social media is full of warnings. Group chats are sharing stories about people supposedly losing citizenship. The headlines are intense, the worry is real, but there's a problem with how this conversation is happening. Fear is moving much faster than facts. Before anxiety fills in all the gaps, it's important to slow down and ask three clear questions. What has actually changed? What is legally possible under current law? And who realistically could be at risk? There is a big difference between political language and constitutional reality. Understanding that difference can be the line between living in constant fear and having grounded, informed confidence. Hi, I'm Timothy, and here I focus on taking complex immigration developments and explaining them in straightforward, practical terms so you can see what truly applies to your situation. Today we're going to unpack what's happening in the 2026 enforcement climate as it relates specifically to naturalized citizens. We'll go through what denaturalization is and is not, why some older citizenship files are being reviewed, which types of cases are drawing attention, what constitutional protections naturalized citizens actually have, and what makes sense to do right now. This isn't about siding with or against any administration. It's about understanding legal structure, process, and verifiable facts. When enforcement ramps up, clarity becomes one of your strongest tools. By the end, you should have a much clearer picture of where you stand and where a lot of the rumors go beyond what the law actually allows. To start, we need to separate two things that often get blended together: the law itself and how intensely the government chooses to enforce it at a given time. Since January 2025, immigration enforcement has once again become a top policy priority. New directives have pushed agencies to tighten compliance checks, expand efforts to uncover fraud, and re-examine older immigration and naturalization records. By early 2026, more staff and more advanced technology were being devoted to looking back at how certain people originally became citizens, especially in files where there might be discrepancies, missing serious pre-citizenship criminal history, or signs that information was not fully disclosed at the time. That shift in focus understandably creates anxiety, but here is the crucial point: the legal framework that governs citizenship itself has not been rewritten. There is no brand new law that suddenly makes citizenship easy to strip away. There is no executive order that allows an agency to cancel citizenship with an internal click. U.S. citizenship, once validly granted, is rooted in the Constitution. It cannot legally be removed quietly, casually, or purely through an internal agency decision. There is, however, a long-standing process called denaturalization. This process has been part of federal law for decades. It is not unique to 2026. Denaturalization is the mechanism the government can use if it believes someone should never have been granted citizenship in the first place because of fraud or concealment during the process. But it can only be pursued through one path: by filing a civil lawsuit in federal court. That means a judge is involved. Evidence has to be presented. The government carries the burden of proof. The standard is clear and convincing evidence, which is much higher than simple suspicion. And the person whose citizenship is being challenged has the right to a lawyer, the right to see the evidence, and the right to defend themselves in court. Without a civil case in federal court, there is no valid denaturalization. There is no legal way to undo naturalization solely by agency memo or database entry. That basic structure has not changed in 2026. What has changed is how aggressively older cases are being reviewed and the tools being used to find potential issues. In recent years, federal agencies have developed far more powerful digital systems that can connect data across many sources. Naturalization files that were once paper only have been scanned. Case information can now be cross-checked with national and local criminal record systems, prior visa, asylum, and green card applications, travel and entry, exit records, and other federal databases. In the past, finding a discrepancy might have required a human being to dig through multiple physical files. Today, software can highlight potential conflicts very quickly. A different date of birth in an older visa application, a a criminal case that predates naturalization but isn't mentioned in the N-400, inconsistent names or biographical details across filings. This is a big reason why some older naturalization cases are being looked at more closely in 2026. But a flagged file is not the same thing as a revoked citizenship. A digital alert is simply a prompt to investigate further. It is not a judgment, and it certainly isn't an automatic loss of status. For the vast majority of naturalized citizens who provided truthful information, met eligibility requirements at the time, and did not hide disqualifying facts, tighter enforcement and better technology do not suddenly create new legal vulnerability. Your citizenship remains protected by the same constitutional framework. So who is drawing extra scrutiny right now? Not everyone, not entire communities, not all people from certain countries. The current focus is narrower and tied to specific legal issues. Broadly, enforcement is concentrating on whether a person's citizenship was lawfully granted at the time it was approved. That means looking backward, at the period before and during naturalization, not at everything that has happened since. Types of cases that often draw attention include individuals who may have had serious disqualifying criminal history before naturalization that was not disclosed on their application. The emphasis here is on serious pre-naturalization offenses, not minor tickets or small infractions. Cases where there are significant differences in identity details across records, name changes that were never fully explained, different dates of birth, or conflicting background information in earlier visa, asylum, green card filings compared to the citizenship file. Sometimes these are honest errors. Sometimes they raise questions about intentional identity concealment. Situations where permanent residence appears to have been obtained through a fraudulent marriage, and that green card later served as the basis for naturalization. If the foundation is found to be fraudulent, the citizenship built on it can be challenged. Cases involving undisclosed involvement with organizations or activities that, under immigration law, would have rendered someone inadmissible at the time of application. None of these categories are new. They have been in the law for many years. What's changed is that discrepancies are much easier to spot now. Equally important is understanding that not every mistake is fraud. Under the law, a misstatement must be material to be grounds for denaturalization. Material means that if the truth had been known at the time, the government would not have approved the citizenship. Examples of things that are typically not material: a simple typo, forgetting to list a very short trip abroad, a minor issue that would not have impacted eligibility. The government has to show that what was allegedly concealed or misstated actually mattered to the decision. That is a real and meaningful legal barrier. If despite all this, your case does come under formal scrutiny, your rights are significant. If an agency believes there was fraud tied to your naturalization, it cannot simply mark a file and erase your status. The only lawful path is filing a civil denaturalization complaint in federal court, serving you notice of that case, proving their claims to the clear and convincing evidence standard. At that point, you have the right to respond through counsel, to review the government's evidence, to challenge both facts and legal arguments, and if necessary, to appeal an adverse decision to higher courts. You are not required to prove you deserve citizenship. The government must prove you were never eligible when you received it. If you get a letter from the government asking questions about your naturalization process, or if agents come to speak with you unexpectedly, you are not required to answer detailed questions on the spot. You can politely say you wish to consult an attorney before providing information. That is a protective, lawful response, not an admission. If a court ultimately rules against someone in a denaturalization case, appeals exist. There are also legal doctrines that limit the government's ability to bring the same claim over and over without new evidence. Now let's tackle some of the most common rumors circulating this year, because separating myth from reality is essential. Rumor: naturalized citizens are being removed in large groups. Reality: even with increased investigative activity, denaturalization cases remain rare relative to the total number of naturalized citizens. These actions are pursued one person at a time based on specific evidence, not as broad sweeps of entire communities. Rumor: using your native language, visiting your birth country, or keeping dual citizenship will get your citizenship taken away. Reality: U.S. citizens are not required to give up their culture or language. Speaking your first language, visiting relatives abroad, and in many cases, holding dual citizenship, if allowed by the other country, are not grounds for denaturalization. Rumor: any crime after naturalization can get you deported. Reality: Once you are a citizen, you are generally not subject to deportation for things that happen afterward, unless your citizenship is first undone through denaturalization. Again, through a court process focused primarily on pre-naturalization conduct. Post-naturalization crimes are handled through the criminal justice system, not by revoking citizenship in a routine way. Rumor: certain nationalities are being quietly stripped of citizenship. Reality: there is no public law granting the government authority to revoke citizenship based solely on country of origin or ethnicity. While enforcement priorities can differ across regions and programs for non-citizens, actually undoing citizenship still requires individualized evidence and a judge. Rumor: because interviews are stricter now, people who already became citizens will be called back and retested for no reason. Reality: standards and interview practices can evolve, but there is no general practice of re-interviewing naturalized citizens just because policies change. There must be case-specific reasons tied to an individual's file. So, what should you do in this environment? If you became a citizen lawfully by being truthful on your forms, meeting the eligibility rules, and completing the process correctly, your status remains one of the strongest legal protections available in U.S. law. Still, increased enforcement means being organized and proactive is wise. Practical steps include keeping thorough records, your naturalization certificate, copies of your original immigration approvals, and, if possible, copies of your N-400 and prior applications. Store them safely, both physically and digitally. If your history includes more complicated elements, like prior overstays, old criminal charges, different names on past documents, or multiple types of applications, consider a private review with an experienced immigration attorney. The goal isn't to assume there's a problem, it's to know where you stand. If you ever receive official mail about your citizenship or naturalization, do not ignore it. Don't assume it's a minor error. Contact a qualified lawyer and respond through proper channels. Early attention can prevent small issues from becoming larger ones. For lawful permanent residents who haven't yet naturalized, the calculus is different. Green card status can be more vulnerable, especially in the face of serious criminal issues or extensive time living abroad. For that group, consistent compliance and, when ready, applying for citizenship are key ways to strengthen long-term security. Big picture, U.S. immigration policy tends to move in cycles. Enforcement surges, courts test the limits, some measures are narrowed or blocked, others stand. That pattern has continued into 2025 and 2026. The checks and balances built into the system are still there. Technology has changed. The ability to find old discrepancies has improved. But the constitutional safeguards and due process requirements that protect naturalized citizens have not vanished. Staying informed and prepared is your best response. If this explanation has helped replace vague fear with a clearer understanding of how the system actually works, consider sharing it with someone who might be quietly worrying without accurate information. Make sure you follow U.S. Updates Hub for fact-based breakdowns as policies continue to shift through 2026. And remember, while general information like this can be very helpful, it is not a substitute for personalized legal advice. If your situation involves unusual history or specific concerns, speak directly with a licensed immigration attorney. Millions of naturalized citizens across the country continue to live, work, vote, build families, and contribute every day. Enforcement priorities may change, but lawfully obtained citizenship remains one of the most stable statuses under American law. Stay informed, stay organized, and move forward with knowledge, not just headlines.